that teachers will be required to notify parents within 48 hours if their child wants to be referred to as a gender identity different than the one listed in their enrollment records. It's the same move that's put the school board in Chino Valley squarely in the sights of a lawsuit filed by California's Attorney General. So, why would another district put itself in that kind of jeopardy, and what recourse do teachers have, if any? For those answers, we turn to attorney Mark Reichel, who's joining me now live. Mark, good morning to you.
Good morning. Thank you.
So before this vote in Rockland, we heard from teachers and their union that a move to this parental notification policy regarding gender identity would put teachers in a position to violate state law. The board went ahead with it anyway. What state law were the teachers pointing to?
California Education Code, as well as the California Constitution about the equal protection of the laws. Each student has the right to this free public education in the best circumstances possible. And so you can't single out different ones for different treatment. That's equal protection. Everyone has equal protection under the laws. The California Constitution applies to minors as well. So you have the right in a school setting to be treated the same as everyone else. That's equal protection. The California Education Code in 2014, the law of the land, said that you cannot out students like this to their parents.
All right, so if state law prohibits teachers from doing this, can a school district decision supersede that? Can a district come after a teacher for noncompliance?
Well, the question is whether they legally can or whether they physically can. So suppose the teacher refuses to comply, they'll send them a letter saying you're hereby terminated. Well, then the teacher gets to sue, and they'll sue in court and say, look, I'm just following the law like I have to. So, and they'll win. And then the school district will have to pay out, but not anybody who works on the school, is on the school board. They don't have to pay out. The county will have to pay out, and eventually the state will have to pay out, because it's not like the school board members have to pay for the attorney fees or any damages to this employee that was terminated wrongfully.
Much like with this situation, several state school districts have recently bucked state law, state policy by rejecting the most recently approved state social studies textbook because it includes lessons about the contributions of California's LGBTQ community. Again, districts are supposed to adopt what's been endorsed as appropriate curriculum for students by panels of teachers, parents, and state leaders. If these rejections are allowed to stand over what some say are moral or religious issues as opposed to factual, historical items, what's to stop a district from suddenly deciding that it doesn't want to use the latest approved math textbook? Like if a district weren't going to switch to the Common Core approach for math, students are just going to be left behind, not getting the same education as their peers?
Yeah, at some point we have to realize, there's a process here. You go to the state legislature, you pass the laws that you think are the best for your interest in the state, but then you just don't have a wholesale disregard for them after that. That's lawlessness. And it's going to be really confusing for students, especially if you move from one school district to the other and you get to the new one and say, wow, we couldn't learn about that in my old school district, or wow, we used to be able to learn about that in my old school district. So it's much better to have uniformity. Higher education, the universities are going to look at your school transcripts, and if yours, they're very aware of different school districts. If yours is one that has decided to have a shortened or limited version of knowledge, that student's going to have to pay for that in the long run.
We know many parents fought for these policies to be enacted in Rockland and Chino Valley, but for the parents who disagree in Rockland, do they have any recourse, perhaps in suing their district for maybe negligence, adopting a policy that's already triggered a lawsuit in another part of the state, incurring more turmoil and expense, even though they had an example of what could happen?
Well, they can certainly sue for what's called an injunction, which is to stop conduct or action from taking place. Sue for an injunction, which says, hey, they can't do this anymore. They have to get rid of their policy. Suing for damages is different. You have to actually prove there's damages that you've been harmed economically or psychologically that can be quantified. So it's going to be difficult to prove, to get damages, to get money for this. But they can certainly enlist with the Attorney General's office to get an injunction that's trying to stop the school district from doing this.
As part of this gender policy controversy, Rockland School Board President Julie Hupp called for the involvement of, quote, Christ-centered parents. We all know our own country was founded on Judeo-Christian principles, but the founders also created the separation of church and state through the First Amendment. Now, Hupp has apologized and sought to clarify her comments, but could someone sue about all of this, claiming their First Amendment rights are being violated under her direction?
Absolutely. So the first thing a court looks at is if there's any racial or strange animus to go after someone unequally. So you look for animus, which is, not evil intent, but not proper intent. So if there's any discrimination specifically against those that are non-conforming gender identifying students, and they say, hey, look, this is coming from the Christian leaders of the school board, then that's obviously something that's selectively being enforced against people based on the religious views of the school board member. It's never going to happen in America in the long run. They can try, but eventually everyone's going to come back to the bedrock principle of America. And that really is that there is a strong separation of church and state. And the reason they did that in the late 1700s was the reason that they had seen all of Europe go through decimating wars forever between competing religious groups. When they established America, it was for the sole purpose to keep religion out of the state, to make them separate. That's why you have freedom to practice religion, but there's also freedom from the government becoming the religion.
Alrighty, thank you so much. This is definitely a topic that families and we are going to be talking about for months to come, so we appreciate your insight.
Thank you.